CEO of the Kenyan Bankers Association, we're so grateful you've brought your leadership to this summit because it couldn't be done without you. And I met with the Governing Council in June, and there was a lot of enthusiasm about moving mediation and making this the first topic. The first conference. As you make your opening statement and introduce yourself, why is it that banks are now so enthusiastic about mediation and see the potential of mediation?
Yeah, thank you, Judge. I think instead of introducing myself, because it has been, let me just quickly jump into the question you have asked. And before I jump into it, I think, let me first of all appreciate all those who have come today to this summit that essentially tries to help us see how mediation can be prioritized over litigation in this country. Let me first of all thank you because it was at that meeting you had with the Governing Council that a decision was made, and the Governing Council actually did give us direction in terms of our priorities this year, and mediation was put as one of the priorities that the banking sector must deliver to the economy. And today somebody mentioned about the fact that we wrote our check in 2 days. Actually, it was a way of me trying to protect my job.
You didn't want to have to,
on my performance,
you didn't want to have to answer to Raymond?
On my performance contract, mediation is clearly there number one. And so if that check was going to delay, I was going to have a very difficult conversation with my senior, at the end of the year. So it was just a way of trying to ensure that, I get it out of the way. Then let me also thank the Central Bank. I think from that discussion, you were actually coming from Central Bank before you came to the Governing Council, and you had already laid the groundwork. So Central Bank has been very supportive, as the Governor mentioned. There's the banking sector charter that created the way for us to be able to roll out the mediation within the banking sector. So for that, thank you very much, Central Bank, for the leadership. Now, I think we all know that litigation has helped us resolve our conflicts, which is true. But I think the future from all the discussions that we had today lies in mediation. Yesterday, I was listening to a conversation over the program called Situation, and it was being led by Justice Mabea. And there's something he mentioned which piqued my attention. He talked about the fact that the traditional African society used to resolve their disputes through mediation. Following to that, I think there was then the colonization and and then somehow litigation picked up. Now we are trying to go back to mediation because it was effective. And we are seeing the challenges that we are having with the litigation. And so as a banking sector, I think we want to lead the way in terms of trying to drive us back into litigation, into mediation as a means of resolving our disputes. Now, in the banking sector, most of the disputes that will arise will involve money and capital that is tied up in those disputes. So a quicker way of resolving those disputes then unleashes that capital back into the economy and therefore be able to drive the economic development of the country, as opposed to all that money being tied up in litigation and disputes and all that. And in fact, the Chief Justice in her speech, I think she tried to give a hint of the kind of money that will be unlocked into the economy if we get this mediation moving forward. In the banking sector, actually, we've realized that the most appropriate and efficient way of resolving any disputes between ourselves and our customers, the other stakeholders, the suppliers, the employees, is actually by having a conversation. And that conversation is best facilitated with somebody, a third party, who is well skilled in helping you arrive at a win-win kind of situation. And that's why we need a mediator. And that's why effectively we are trying to promote or make mediation as a preferred way of resolving our disputes within the banking sector, because it's more or less an issue of our mutual interests rather than our rights that carries the day. Now, when you look at litigation, I think one of the critical things is that the court tends to remove the powers from us as people in dispute. And then, because we can then resolve our disputes based on our mutual interests. And when we go to the courts, we actually remove that power and give it to a judge, who then on the basis of the law will make a resolution that will then bind us. So in a way then, one of us loses and one of us wins. The loser not only loses but occasionally is punished for that. And so that's a situation whereby it's not a win-win situation, it's a win-lose situation, which then does not promote the kind of relationship that you want to build for a long-lasting relationship with a customer. Hence the need for us to go the mediation route. And I think, lastly, the point I mentioned about the courts deal with rights, while businesses, we are actually more concerned with the interests rather than rights. And therefore, when we examine our interests in a mediation environment and we negotiate on that basis, we more or less arrive at a better win-win solution rather than having a win-lose situation, as I mentioned earlier. Thank you.
Encourage those institutions to build into their agreements with vendors, with customers, a mediation clause. Do you think that's something that could be helpful?
You know, I think at this stage it's really that opening stage, and what we're looking at is what is happening around the world and how it's working. And obviously having you as an expert in this area leading us, then that's really helpful. What I get concerned about is that we start proposing regulations or structures before we've actually tested the system. And, you know, I was looking for some information and some background when I was doing the prep for this discussion. We had 3,000 cases approximately last year, year 2022, that were referred for mediation by the courts. And of those, 72%, 2,000 approximately, actually went for mediation. And then when we looked at it again, what we saw is that 50% of those cases that went were resolved successfully. Now, this is a small sample, but it tells you a lot of what's possible. So now that we have this data, and hopefully we'll be able to get some more data, then what we'll be able to do is see how do we build on that? Because what we're saying is we're still starting from a fairly low base. I think the other thing that's important that we need to think about is what is the experience of the banks that have currently engaged mediation? And I talked to one of our CEOs of our banks, and what he was saying to me is that he's seen 2 immediate results. So this is his first cohort that he has trained in mediation. And he said that when they go for debt collection, he's having a better outcome, i.e. the bank is benefiting commercially, financially, from having this cohort because they're going in a different way. And as a result, the loanee is more able to explain their challenges and there's more listening, and as a result, the outcomes are better. And he said the other outcome that he got that he wasn't expecting is that the staff that he has trained are very conscious of their behavior now. So even in the office, the collaboration and cooperation between his senior staff it has improved significantly. So he said he's now going to get the second cohort to go for training. So I think these are the issues that we need to think about. And very quickly, if I may, today I heard something that I hadn't heard before, which I think is very important. 10% of Kenyans have the ability to get justice. Mm-hmm. So I don't know why the judiciary would be asking the central bank for support. That statement itself is so powerful. There is nothing that we could influence that would be more powerful than that. Thank you.
Yeah, and that whole issue, of course, part of it is also a PR, a public relations issue. It's like the public recognizing when the judiciary is trying to resolve things fairly. How do you get the public motivated? How do you educate in law schools? How do bar associate? I mean, education on the ground is so critical because, I mean, in the United States, 50% of the people can't get a lawyer because they can't afford a lawyer. It's a common problem. And you mentioned this issue of training. So we are talking about, and also being methodical, step by step, being very analytical. The groups that are working on this are very strategic. You know, this task force we have. But the training, I just want to ask you this, that was not only, or you tell me, I don't want to lead, was it just in-house lawyers? Was it employees of the bank that handle disputes, because banks have dispute resolution? You know, did the training go to that level?
From my understanding, the training was of staff and creating a center within the bank that could deal with disputes through mediation. So that involved also bringing in external parties if that was the right structure. So I think that that's what I was being told, and I was being told it's having good success. Thank you.
And speaking of disputes in banks, do you think there's a dollar limit, or there are certain kind of disputes that wouldn't be suitable for banks? You know, what kind of disputes are banks involved in that you think are suitable for mediation? Is it everything? What's your view?
Yeah, thank you. I think I'll start from my chairman's remarks just a few minutes ago. That's John Gashora. And there's something he said there about the fact that the banking industry is focused on referring all the disputes in the first instance to mediation. Of course, there are some exceptions. I recall the discussion I mentioned about where Justice Mabea was on a discussion yesterday about mediation and banking, and it's still fresh in my mind, that's why I'm referring to it. And he referred to something about cases that are excluded, that are not possible to be referred to mediation. And he talked about criminal cases, and I think he also talked about constitutional and legislative interpretation, and then of course public interest cases. But all those exclusions account for less than 5% of the disputes that arise within the banking sector. So it therefore means that the balance can actually be mediated and resolved through mediation rather than directly through litigation. So with that basis, therefore, it looks like all the other banking industry disputes are suitable and capable of being settled through mediation. And if you look at the kind of disputes that will arise, most of them will be to do with the loan defaults, debt collection. That will be the bulk of it. We'll also have disputes to do with the guarantor disputes, which is also linked to debt collection in a way. We have got liability issues, breach of data breach and the like. We have got money transfer because banks, part of their role is to facilitate payments. And within the money transfer sphere, be it RTGS, be it the EFTs, be it the checks, be it the mobile money, be it debit and credit cards, be it internet banking, all the others, they'll occasionally arise disputes. And all these are actually resolvable through mediation. Things like personal injuries, liquidations, staff disputes, whether it is through union or non-unionizable, all of them are resolvable through mediation. So my appeal to all parties that are currently having court cases in court, please take advantage of this opportunity to have your cases removed from court and taken through mediation, because that way you'll have a much faster way of having your cases resolved. You'll have a much more efficient way. It will save you money and time. Yeah, and I think also the fact that actually you'll still have a relationship with the customer even after resolving the dispute. Unlike going through the litigation way, where one party loses, one wins, and at the end of the day, there's no relationship thereafter.
And I saw you. Kareem, nodding your head when Habil was saying he thought all the cases, with very few exceptions, that are banking cases could go through mediation. I take it you agree with that?
No, I agree completely. I think anything broadly which is a commercial dispute should be capable of mediation. The only exception I would add to maybe Habil's list is, mediation is obviously a voluntary process, right? By definition, you can bake it into a contract to say that you will first mediate, but in essence, it requires the parties to want to mediate. Otherwise, the mediation fails. And I think we should recognize. I suspect a bit like the U.S. In Kenya we have no justiciability threshold to file a case. Okay. So often cases are filed at a whim with really no legal basis, simply to create a negotiating posture of some sort. And often in that scenario, delay or embarrassment are the two motivating factors, right? For the case to be filed, not the underlying legal rights as such. So I think that's the one other scenario in which mediation is unlikely to be super successful, at least at the start, right? Because there isn't what I would call, probably not the best expression, but there isn't a good faith dispute, right? There's simply using litigation as a tool to effectively have a commercial dispute by other means, right? And I think that's one exception I would probably add to.
Well, and then certainly the role of the courts in court annex mediation, because that's where there is a distinction.
Right.
So in private mediation, the parties have to agree to go see a private mediator. The key in the U.S., at least that was my experience, because I spent 15 years as a trial judge, and I did mediation 50% of the time. When it's court annex, when the court can say, you must go mediate. Therefore, if I'm the plaintiff, I used to say this all the time, make a demand, do a response as a defendant. When it came from the court, it took people off the hook, because then you didn't have to appear weak, so that you could. So I think court mandated mediation helps jumpstart an economy and gets people in the habit of court annex mediation.
No question about it, and I think, and obviously there's encouragement and encouragement, right?
Yes.
And judges can use both forms of encouragement, if I can put it that way. The one is, look, there's court-mandated mediation, as a step, or there's, I really suggest you sort your dispute out through mediation, right? Much more suggestive which I think would be very helpful.
Yeah, and then the other thing courts can do in terms of help desks inside the courthouse. So you're talking about some of this frivolous litigation. You know, part of how we've addressed that in the US, and we only did this in our district court maybe 15 years ago, we created a self-help desk. And so now we have lawyers from the bar who volunteer, you know, 1 day a month, so that pro se represented people can come, and they're not going to represent them, but for example, if it was this kind of frivolous dispute, I mean, the court can actually refer somebody, you go see the help desk before we go any further on this, so that you could have them have the assistance of a lawyer to evaluate. I mean, that's one of the real issues of access to justice. How do you educate the public? What kind of publications? How can we do things online to get people educated? Javed, do you, in terms of this issue, the role of lawyers and as facilitators versus being warrior, what I like to call warrior lawyers, have you seen a change in attitudes in the United States toward mediation?
I do think so, and I think the point about training, of course, is all important. These are not necessarily instincts or talents that everybody comes to, without some training. And I would say that, even for being doing negotiations with, in a transactional situation, sometimes we as lawyers in a law firm get training. I have actually a classmate who wrote a famous book on negotiation called Getting to Yes. And there's some really good tools in that book and similar other publications which actually suggest ways of doing it. I want to come back to the whole point that you asked the Deputy Governor about, escalation clauses in contracts. And I think all of you lawyers, I'm sure many of you already know this, and perhaps all of you do, but the standard classic agreement, especially if it's a large commercial transaction, the very standard clause, which in my experience has worked really, really well, which is, hey, if you have a dispute, we two, the project manager and the client, get together and talk it out in maybe that you put some format around it, some procedure. If that doesn't work within X days or X weeks, you get your CEO of your company and the head of your bank, or whatever the analogy is. If that doesn't work, you go to mediation, and then of course you have all those discussions of, is the mediation voluntary, is it mandatory? Is it under the rules? I mean, a lot of for example, UNCITRAL rules have, procedures on mediation. And if you don't like the result, can you ignore it? Those are all decisions that have to be made. But I'll tell you one really great thing about mediation is to speak to the point about frivolous lawsuits, because those happen at the billion-dollar level as much as they happen at the 25,000 shilling level. When you go through mediation, especially if you have a trained mediator who is helping you do this, you quickly recognize that some of the claims are totally bogus. And so if nothing else, you narrow down the dispute to something that's really a good faith dispute. And that in turn can lead to an immediate resolution in the mediation context. But even if you go to the next level of formal arbitration or formal litigation with all the costs associated with each one of those options, you're at least dealing with a much more limited scope of dispute. Mm-hmm. And all that is, I think we're all here to say, if we can keep our economy strong and focus on the things that are actually productive as opposed to what in many ways is except for lawyers' fees, kind of wasted time, effort, and money locked up which cannot be recycled back into the economy, then it's a great thing if when you even have a good faith dispute, you get to the other side quickly because you did spend the 2 weeks on mediation.
Well, and the other thing too, if you have a very experienced mediator and it is a frivolous case, let's just take one of those frivolous cases you talked about, the mediator can build a rapport with the parties and hopefully bring some understanding. That doesn't mean that the plaintiff will withdraw it, but at least it's a reality check. that can be helpful. I mean, I did a lot of prisoner cases, and we did those by phone. The inmate would say, I don't like the kind of food I'm getting every day. Well, that was not a claim. That wasn't cruel and unusual punishment. But I would talk to them, one-on-one, and, with my court reporter, you realize that, to tell me where is it in the law, where it's in the statute, how is it, so like, you really recognize there's nothing to this. I mean, at some point, it can work, it doesn't have to. What do you think? I think, Javed, you shared that 5-time client that came back to you. Was there a recent case you just did that we talked about in banking?
It's ongoing now, so I'll let that one go. But I think really this works in all sectors. I mean, that's really the point. Whether it's infrastructure, it's construction, it's banking, it's the broad range of commercial disputes about I licensed you my technology only to do this much, but now you're doing this much. And those things, if you go into formal dispute resolution like a court, the intellectual property cases can go on for years and cost millions of dollars in legal fees. And if you can get those in front of an experienced mediator, you can solve them much more effectively. And actually, maybe this isn't the right time, Judge, but I just make this point. A mediator doesn't have to be a lawyer. Sometimes the right mediator is an engineer, he or she's a quantity surveyor. It's, especially now with all of the fintech stuff, there are people who have skill sets that we white-haired lawyers would love to have but don't. So I think the range of people who will be doing mediation, whether it's here with the booming economy in Kenya with all the things that Kareem described, or
and the Governing Council actually did give us direction in terms of our priorities this year. And mediation was put as one of the priorities that the banking sector must deliver to the economy. And today, somebody mentioned about the fact that we wrote our check in 2 days. Actually, it was a way of me trying to protect my job.
You didn't want to
Because
have,
on my performance,
you didn't want to have to answer the
on my
Raymond.
performance contract, mediation is clearly there number one. And so if that check was going to delay, I was going to have a very difficult conversation with my senior, at the end of the year. So it was just a way of trying to ensure that, I get it out of the way. Then, let me also thank the Central Bank. I think from that discussion, you actually coming from Central Bank before you came to the Governing Council, and you had already laid the groundwork. So Central Bank has been very supportive. The governor mentioned there's the banking sector charter that created the way for us to be able to roll out the mediation within the banking sector. So for that, thank you very much, Central Bank, for the leadership. Now, I think we all know that litigation has helped us resolve our conflicts, which is true. But I think the future, from all the discussions that we had today, lies in mediation. Yesterday, I was listening to a conversation over the program called Situation, and it was being led by Justice Mabea. And there's something he mentioned which piqued my attention. He talked about the fact that the traditional African society used to resolve their disputes through mediation. Following to that, I think there was then the colonization and that, and then somehow litigation picked up. Now we are trying to go back to mediation because it was effective. And we are seeing the challenges that we are having with the litigation. And so, as a banking sector, I think we want to lead the way in terms of trying to drive us back into litigation, into mediation as a means of resolving our disputes. Now, in the banking sector, most of the disputes that will arise will involve money and capital that is tied up in those disputes. So a quicker way of resolving those disputes then unleashes that capital back into the economy and therefore be able to drive the economic development of the country, as opposed to all that money being tied up in litigation and disputes and all that. In fact, the Chief Justice in her speech, I think she tried to give a hint of the kind of money that would be unlocked into the economy if we get this mediation moving forward. In the banking sector, actually, we realize that the most appropriate and efficient way of resolving any disputes between ourselves and our customers, the other stakeholders, the suppliers, the employees, is actually by having a conversation. And that conversation is best facilitated with somebody, a third party, who is well skilled in helping you arrive at a win-win kind of situation. And that's why we need a mediator. And that's why effectively we are trying to promote or make mediation as a preferred way of resolving our disputes within the banking sector. Because it's more or less an issue of our mutual interests rather than our rights that carries the day. Now, when you look at litigation, I think one of the critical things that the court tends to remove the powers from us as people in disputes. And then, because we can then resolve our disputes based on our mutual interests. And when you go to the courts, we actually remove that power and give it to a judge, who then on the basis of the law will make a resolution that will then bind us. So in a way then, one of us loses and one of us wins. The loser not only loses but occasionally is punished for that. And so that's a situation whereby it's not a win-win situation, it's a win-lose situation, which then does not promote the kind of relationship that you want to build for a long-lasting relationship with a customer. Hence the need for us to go the mediation route. And I think, lastly, the point I mentioned about the court deals with rights While businesses, we are actually more concerned with the interests rather than rights. And therefore, when we examine our interests in a mediation environment and we negotiate on that basis, we more or less arrive at a better win-win solution rather than having a win-lose situation, as I mentioned earlier. Thank you.
Yeah, and so this mediation also saves more money and time than arbitration. Like your bank has been involved in arbitrations, which is just almost like being in court, right? Yeah, and so mediation cuts the time, and then it also helps, I think, equal the playing field, because many people will be unrepresented in mediation, but because the mediator is there as the neutral, can make sure the power is balanced. You agree? And you mentioned the word trained mediators. So one of the things that's going to happen here at Strathmore is additional training of existing mediators on issues relating to banking and commercial law. Because if you don't have confidence in the mediator, is that a problem?
It's good you mentioned that, because one of the experiments that we did was we actually had a KBA mediation center here at Strathmore in partnership with the Strathmore Law School. And I think the lessons that we learned from that experiment will go a long way in supporting us in terms of getting the way forward.
Right, and I remember that because that was 2018, which that pilot did well in terms of resolving a number of cases, but it didn't go anywhere beyond that.
Yes.
You know, there wasn't like a long-term commitment. And a strategy, and so a strategy is necessary to move things forward. But that was really brave, I think, of the banking community to even do that in 2018. So there was a recognition even then how important mediation could be. Let me turn to you, Kareem, on the attitude of advocates, because you've been in practice of law for quite a while. And your law firm is one of the leading, if not the most, the #1 law firm here in Kenya. How has the attitude of lawyers or advocates changed in terms of Kenya, and what are we to expect in the future from an advocate's point of view of mediation?
Thank you, Judge Atino. Allow me to first thank Strathmore, Gil Kunjera, the Vice Chancellor, all the sponsors, KBA and Jones Day and so on. It's a real privilege to be here. Perhaps I can answer your question. It's not so much the attitude of lawyers that has changed, but I think Kenya has changed dramatically over the last 20, 25 years, and that's forced us all to rethink dispute resolution. Kenya has now emerged as, one could say, a sub-Saharan, but definitely a regional champion in financial services. So the largest financial houses in our region are headquartered in Kenya. And that's just not banking, but you'd be surprised to know that last year there was over $1 billion invested in the fintech industry in Kenya alone, right? Over $1 billion. And that's a whole range of different financial technology solutions. And these are, as you'd expect, sort of all targeting the mass market. So there's a really much larger connectivity between the financial services sector and the overall population in Kenya than there is in many other countries. I don't even need to mention M-Pesa and all the offshoots from M-Pesa and similar products. So I think that's an overall context. And one can't really be a credible regional financial center if you don't have credible alternative dispute resolution. Right? The two go hand in hand, and I certainly know when our clients are evaluating Kenya as an investment destination, one of their questions to the lawyers is, well, tell us about how do we resolve disputes. Do we have to go to court? How many stages of appeal? Are the courts corruption-free? Is there an alternative to courts? And so on and so forth. Right? So being able to say that you have a credible ADR, whether it's arbitration or specifically mediation, is, I think, an important comfort to investors, both local and foreign. So I think that's one part of it. The other part of it is, and forgive me, but the rule of law is important to me. But there is the most chronically underfunded arm of government is the judiciary. Right? There's tons of data, academic papers written on this that demonstrate that relative to the executive and parliament, the judiciary is chronically underfunded, right? And systematically so through governments. So it's not this government or that government. It's a systematic thing over the last couple of decades at the very least, if not longer. So the judiciary has a real vested interest in promoting ADR and mediation because it has to make the best it can with the limited resources that we have. To compound that, we're obviously in a fiscal, difficult moment, not just in Kenya, but emerging markets generally. So everyone's tightening their belts. The judiciary will have to tighten its belts, like everyone else. And so I think there's really a moment now for imaginative thinking around the use of mediation, unclogging the courts, for all the reasons that have already been discussed extensively today: time, delay, cost, and so on. There is another, but the story in Kenya is positive in that, because many of you will know we have a tradition now of tax disputes with the KRA going through alternative dispute means. The NCIA has a standing list of accredited local and international mediators. So I think there is solid ground on which the banking sector can now develop its own mediation. And so I think that's the context. Now, as for lawyers, I think the argument that this is a lose-lose is just not right. As far as, we are first a vocation, second a business, right? So that's the main point about the lawyer. Firstly, a vocation. You must always act in your client's best interests. And inevitably, generally, your client's best interests are to resolve the disputes as quickly, as expeditiously, and as cheaply as possible. And in fact, I think that works out the benefit of the lawyer, because the more you can build a reputation for being an effective proponent of your client's best interests, the more likely you are to get more clients.
Well, because the word spreads, doesn't it? In the community,
Absolutely.
in the business community?
Absolutely. When you go to lawyer X, you won't be stuck for 10 years. Instead, lawyer X will be creative and will find a solution for you much more quickly. Right? So I think there is a win-win here for the legal profession as well. And I think, this is probably my final point. I think we can be very proud of the work that the universities like Strathmore and others have done to produce better and better quality graduates. And certainly in the African context, Kenyan lawyers are now, if you look at the number of lawyers who are accredited and globally recognized by various bodies, we're up there, together with, I would say, the Nigerians and the South Africans. So, yeah, maybe that's, I don't know if I've answered your question.
No. deputy governor is here, and each member of the panel has allowed me to call them by their first name, as they will call me by mine, Atieno. And I want to direct the first question to you, Sheila. I remember when I came to your office in February, met with you and the governor, you were very excited about this conference. And as you make your opening remarks, why do you think mediation in the banking and financial sector is so important to the central bank and the people of Kenya?
Good afternoon, everyone. Thank you for giving me this opportunity to talk today. Let me just recognize all protocols observed so that we don't spend a lot of time on that. I think what I want to say is that the financial sector is the money artery of the economy. And as we know, where there's money, there's disputes. And so mediation is very linked to the financial sector. The CBK's mandate to mediation is financial sector stability. We don't oversee individual banks, they have their shareholders. But the Central Bank of Kenya is responsible for the financial stability of the economy, and it's in that sense that we manage. Obviously there's banks, mortgage finance, foreign exchange bureaus, payment service providers, and credit-only lenders. All of these people will be oversighted by the central bank. And therefore, as I address today, I want to be seen to be addressing the stability issue. Stability is founded on fairness, is founded on a structure, is founded on governance, it's founded on transparency, oversight and enforcement. So those are the pillars, if you like, of ensuring that there's going to be a stable structure. And these structures, if done well, what they lead to is trust, relevance, equity, timeliness, and affordability. And so what we're saying is when we think about mediation, these are the pillars that we need to put in place. And as a result of those pillars, that will be the outcome. The complexity of the financial systems domestically and globally today cannot be overstated. And the instability that is in the system, as we currently see it, is more interrelated and of a greater significance than it's ever been before. And so there's even more need for us to look for different alternative ways of managing this increasingly complex, increasingly large system. The financial sector regulators should walk with innovators. We do not want to be behind, because if we're behind, we cannot see the dangers ahead. We don't want to be ahead, because if we're ahead, we block good ideas. We want to walk beside. Mediation is one of these good ideas, and the financial sector has begun this journey. It provides a valuable alternative to the existing structures that we have. However, for mediation to be successful, it must be fair, relevant, affordable, and timely, driving trust and equity. Thank you very much.
Yeah, and let me just ask you this. One of the things the governor said was high interest rates in Kenya, the banks make the rates higher because they know about the default rate, they know how long the cases are. That's another way embracing mediation can have an impact on that, or you're hopeful.
I think that markets drive the rates, as we've said many times, but what's important is for people to understand what contract they have entered into. Now, if mediation allows that kind of openness and that better understanding of what contractual terms people have entered into, then I think it would make a difference, yes. Thank you.
Thank you. And Javier, you know, CEO of the Kenyan Bankers Association, we're so grateful you brought your leadership to this summit because it couldn't be done without you. And I met with the Governing Council in June, and there was a lot of enthusiasm about moving mediation and making this the first topic. The first conference. As you make your opening statement and introduce yourself, why is it that banks are now so enthusiastic about mediation and see the potential of mediation?
Yeah, thank you, Judge.
I think instead of introducing myself because it has been, let me just quickly jump into the question you have asked. And before I jump into it, I think let me first of all appreciate all those who have come today to this summit that essentially tries to help us see how mediation can be prioritized over litigation in this country. Let me first of all thank you because it was at that meeting you had with the Governing Council that a decision was made